for some time, and I think it's my honor to ensure that we cross over to the other side for those of us who would be interested to understand what's happening so that we get that. So I'll leave you with that. My name is Linda Alela. See you again at 4 p.m.
A number of impeachments with Dr. Muthomi Dankolo, and we have appeared before special committee and we have appeared for plenary. The plenary allocates all parties 1 hour each for an opening statement. That is exactly what happens in a special committee. The plenary allocates the same hours for presenting evidence and testing through cross-examination. That is exactly what is done in a special committee. The plenary allows parties to have a 1 hour argument for closing arguments. That is exactly what happens in a special committee. My lords, therefore, there is nothing that stands on trying to create this distinction that there is a distinction between a special committee and a plenary investigation. Never mind that we still insist that Article 145.3 still, that word may, gives the Senate the same power, because at the end of the day, it is the same investigation just done within the discretion of the Senate. But let me now turn to the substantive areas, and I'll start with public participation because a lot of heavy weight has been made around public participation. The areas of public participation fall under 3 instances. There is the public participation at the National Assembly, public participation at the Senate. These all involve the impeachment, but there is also the public participation being alleged, what was never done, on the appointment of my client, Professor Kithure Kindiki. Well, the starting point, of course, has to be Article 118 of the Constitution. What does Article 118 say? It says that Parliament, the word here used is Parliament, not Senate or the National Assembly. They are all viewed as one. And it says that there are 2 obligations when it comes to public participation. 1, it shall conduct its business in an open manner, and its sittings and those of the committees shall be open to the public. That is 1. 2, it shall facilitate public participation and involvement in the legislative and other businesses of Parliament and its committees. My Lord, this area, first of all, Ms. Danji told you that the Senate carried out a public participation role. And she tried to tell you that it was in fulfillment of Article 118 and Article 10. My Lord, that is precisely what Article 118 says. It says that Parliament must conduct its business in public. So therefore, when the Senate conducts the impeachment proceedings in public, where everyone is witnessing whatever is happening, it is in effect fulfilling its mandate of public participation. So that is the context within which that Ms. Danji was saying that that Senate also exercises public participation. But my Lord, when we are speaking on the issue of public participation in the context of impeachment, because my Lord Justice Ogola asked yesterday, every party is saying case to case, let us contextualize what this case to case, and therefore I'll be distinguishing what the petitioners have said in their case and what we are saying in our cases. The starting point has to be Justice Kariuki Mate. Why do we start from Justice Kariuki Mate? Justice Kariuki Mate, as Dr. Muthomi has mentioned here, confirmed that the impeachment timelines are on the same level as constitutional timelines. They are cast on stones. Not even a court order, because what had happened in Justice Kariuki Mate, the High Court had issued a conservatory order restraining the County Assembly from impeaching Governor Wambora. It proceeded with that impeachment. The issue was raised of whether the Speaker had acted in contempt, and the Supreme Court says, because of these constitutional timelines, the Speaker could not have acted in contempt, because these timelines are non-modifiable, they're non-alterable, and they're strict constitutional timelines. And my Lord, if you look at that decision, I like how the Supreme Court starts on this issue. Before going to the impeachment timelines, it starts with the constitutional timelines in the context of elections. And it makes perfect sense, because the timelines we are talking about here are the timelines Kenyans were so much concerned about, that we have disputes relating to elective office that can stay for long without having any clear way of how who is representing the people. And therefore, when we introduce constitutional timelines for the purposes of determining electoral disputes, those timelines cannot be viewed in the context of electoral disputes only. They must be viewed also in the context of impeachment timelines. And that is the analogy within which the Supreme Court flows from the point of talking about constitutional timelines to impeachment timelines. But they cited Justice Kariuki Mate to you. But what did they cite? They cited the obiter dictum of Justice Kariuki Mate. Because the ultimate finding of Justice Kariuki Mate was that these timelines are in the same level as constitutional timelines. So when they cite some colorful words here, that timelines can be tested, that standing orders are not inoculated from judicial review, the Supreme Court is saying, yes, that is the case, but in this particular case, these timelines are okay. And my lord, the timelines in the Embu Standing County, the Embu County Assembly Standing Orders actually provide for 7 days. In this case, the National Assembly provides for 12 days. So nothing can be heard from that argument that these timelines are so short so as to have an effect on Article 118 and Article 110 and Article 10 of the Constitution in a negative sense. These timelines have already been upheld by the Supreme Court. It means that because of Article 163(7) of the Constitution, the Supreme Court decision being binding, this Honorable Court will be very much persuading it that it should not get into that area of declaring timelines in the standing orders and Constitution. But after we have established that these timelines are constitutional and are not cast on stone, then we understand that the public participation in impeachment, in the case of the National Assembly, must be conducted within 12 days. So therefore, if it must be conducted within 12 days, we need to ask ourselves what is reasonable within these 12 days. Let's go to Sonko, because Sonko raised the exact dispute that the petitioners are raising in this case, and they cited Sonko to you. Sonko had said that he had been impeached without public participation done in Nairobi County. He was impeached in the exact way. County Assembly impeached him. The Senate also did a plenary investigation. And what does the Supreme Court say in this? My Lord, I'm referring to paragraph 145 of the Supreme Court decision in Sonko. The Supreme Court asked this question to arrive at the conclusion on whether there's public participation. It asked, were there notices of this impeachment motion? The Supreme Court says yes. It asked, was there advertisement in a newspaper with wide circulation in the Daily Nation and the Standard? The Supreme Court answers. It has, were the public given an opportunity to tender in their submission on this impeachment motion? That was done. It has, what was the form within which the public was invited? It notes that there were questionnaires, and it says this is good. The questionnaires were used so that the public can submit their thoughts on this. And then, but most importantly, it asks, was the impeachment motion carried out in public? Was there live coverage of this? And by the way, this flows from Article 118. Article 118 says, unless it is for very specific reasons, everything must be done in public, and it's only for very specific instances that the Senate can be allowed to go in camera. My Lord, the Supreme Court has tested the question of public participation in an impeachment. And it has answered that question by looking at exactly what the National Assembly did in this case. So on what basis would the petitioners cite Sonko to tell you that public participation was not sufficient in this particular instance? But having seen what the Sonko decision does this, the Supreme Court does not stop there. It goes to the Finance Act decision, and here I'm going to refer to paragraph 125 of the Supreme Court decision in Finance Act. And I'm going to quote exactly what the Supreme Court said, because I've already established that there are timelines here. The Supreme Court says this: timelines, whether statutory or constitutional, and the cost implications of the modes and approach to public participation should be taken into account in deciding whether Parliament has complied with its obligation to ensure and facilitate public participation. Therefore, where evidence is proffered, and in my lords, in this case, there is evidence proffered that Parliament was required to pass a bill within a specified period of time. Let's change the words here. Passing a bill to was required to carry out an impeachment within a specified period of time. This factor will be accorded weight in determining the reasonableness of the measures put in place to facilitate public participation over the concerned bill, in this case, over the concerned impeachment. It is within this framework that we must analyze the appellant's contention that the Court of Appeal ought to have appreciated and taken into account the unique nature. Again, the government was saying that the Court of Appeal in saying that that the Parliament has not carried out sufficient public participation in the Finance Bill of 2023, had failed to take into consideration the unique nature of the bill in question. In this case, we'll be saying that if you agree with the petitioners on the type of public participation that should be carried out in this case, there will be a valid concern that the court will not have taken into consideration the unique nature of an impeachment function carried out by the National Assembly. It is within this framework that we must analyze the unique nature as a time-bound legislation in determining whether the National Assembly satisfied its duties to facilitate public participation and involvement in the legislative process. Lord, if you take into consideration the unique nature of the impeachment function according to the National Assembly, you will find, without any doubt whatsoever, that the public participation done in this case was reasonable. Well, Lord, let's look at the cost implication nature. And let's weigh that against the concerns raised by the petitioners. They tell you that there is need to do more than what the National Assembly did in this case. Dr. Mudomi referred to the issue of doing 46,000 polling stations. Well, if the National Assembly was to carry out public participation in all those areas, are we not concerned about the cost implications that would have arisen? Well, we have been in this country, and we can be sure to know that there would have been a more valid concern being said that Parliament has spent unreasonable amounts of money to conduct a public participation in respect of an impeachment. Because if that has to be done within those timelines, there will be monumental resources that have to be deployed there, and it will implicate other constitutional values on fiscal responsibility, on what needs to be done, yet the Constitution says facilitate public participation. On the question of public participation in the Senate, my Lord, once the Senate is conducting this impeachment in public, that is fulfilled public participation. The decision of your brother in Kawera Mwangaza confirms this, that the Senate cannot carry out public participation. Public participation is done at the Assembly's level, and that's what the Constitution says, Parliament. So it says Parliament and National Assembly and Senate are both houses of Parliament. When one of them has already carried out public participation, on what basis will the Senate be carrying out public participation, especially given the unique nature of the function being done by the Senate in this case? It is sitting as a trial court. It cannot carry out public participation in that respect. So, my Lord, I think this contextualizes what is sufficient public participation in the context of an impeachment. The Supreme Court, if I was to interpret the words that it's saying here, public participation is reasonable where the public is aware. Is the public aware that the Deputy President is being impeached? Do they have a feeling of whatever is happening in that impeachment? Because the Supreme Court is avoiding a situation where a citizen will be embarrassed 2 years down the line after the impeachment was carried out. They don't know that the Deputy President that they thought was the Deputy President is no longer Deputy President. So, my Lord, will be persuading you on this basis that the public participation carried out in this case, and the enormous evidence that was submitted by the National Assembly in this case, satisfy that test of public participation. Well, let me revert now to the public participation in the context of the nomination and nomination and election. I'm using the word election very advisedly because the Constitution says in Article 149 that once the President nominates his candidate to fill up the vacancy of the Deputy President, the National Assembly shall vote on that nomination. But this issue, most importantly, was raised by members of Parliament. It is not something that was not raised by members of Parliament before the Speaker. A number of things were raised before the Speaker of the National Assembly on the date that the Speaker read this nomination to the members of the National Assembly. And they asked the Speaker, should we carry out public participation before we carry out this vote? They asked the Speaker, does the Public Appointments Parliamentary Approval Act and Standing Order 45 apply in this context of this vote that we are about to carry out? And the Speaker did a response to these questions. But now, this is communication number 54 of 2024. This is how the Speaker responds to this question. On the first one, he says, that the Constitution language in Article 149(1) explicitly states that the House must vote on, not approve the nomination. And the Speaker is supported by the Constitution. He says, if you have any doubt, look at what Article 132(4) says, what Article 152 of the Constitution says, what Article 156 of the Constitution says, what Article 154 of the Constitution says, what Article 155 of the Constitution says. All these have something in common, my Lord. Whenever Parliament is required to approve and appoint a nomination of the President, it uses very specific language. And if I can use by way of example, in Article 132(4), because this is where the Constitution states of the provisions I've alluded to, it says this. Article 132(4) of the Constitution says, the President may, with the approval of Parliament, declare war and the other issues to do with performing any other functions, including nominating all these people. And I can go to the other example that I can use in this context, my Lord. It's Article 132(2). Article 132 says this: the President shall nominate and with the approval of the National Assembly appoint. That language is consistent in all these provisions I've mentioned. The President nominates and with the approval of the National Assembly appoint. But what is the language used in Article 149? The President nominates and the National Assembly votes. And the Speaker also says that is not the only instance we have in this Constitution where there is a vote that is carried out. He says, let's refer to Article 106. Article 106 of the Constitution requires the National Assembly and the Senate to elect the Speaker and the Deputy Speaker. And he says, in all these instances, we are not required to carry out public participation because it is an election. We are sitting as an electoral college to make this vote. I mean, there is no reason why not to understand this. And there is a lot of double speak on the part of the petitioners. When they want to tell you that their client or the first petitioner was a deputy president, they insist that this is an elective office. But all of a sudden, when it comes to filling that vacancy, they insist that this is an appointing office. How can that be the case? If the office of the deputy president, we decided it is going to be an elective office, in case of any vacancy arising in that office, it must be also an elective office. Why? Because unlike all these other people that I've mentioned, when the president nominates, them and Parliament approves, the president can dismiss them at his will. But the president cannot dismiss a deputy president once he has been elected into that office. The only way is that the way the first one was removed from office is the only way the second one can be removed from office. But therefore, if this is the determination that has been made by the National Assembly, we all agree in this room that the High Court has the last word on the proper interpretation of the Constitution. But my Lord, there is an interpretation that has been proffered here by a co-equal arm of the government. And I'm glad that the Supreme Court itself has had an issue with this. In the case of Owino Uhuru, we have attached that as authority number 10. The Supreme Court says that there are instances where you can defer to the decision made by a constitutional body or accord it a presumption of regularity. And the Supreme Court gives the condition that when you're going to apply when you're going to when you're going to defer to the interpretation by another co-equal arm of the government. And it says that if the decision is within the bounds of the law, that decision is to be deferred to or be presumed regular. If the decision followed established procedures, and in this case, the Speaker said that we are following the established procedures. We do not carry out public participation when we're electing the Speaker, the Deputy Speaker, or even the members of regional bodies such as IALA and the Pan-African legislature. Those instances, no public participation is carried out. Well, it is also a holistic and whole interpretation of the Constitution. If you agree with the interpretation accorded by the petitioners, you would be arriving at an absurd interpretation of the Constitution because it would have the effect of invalidating all those other elections of speakers, deputy speakers that have been done, and even future in doing this. And most importantly, the decision of the Speaker in Communication number 54 was done in good faith. There is no evidence that has been adduced in this stage to demonstrate that this was not done in good faith. Well, having dealt with the issue of public participation, let me return to the fair trial issue and the authorities that have been alluded to by the petitioners. Well, they raise two fair trial concerns. They say that the first petitioner, impeachment, was expedited. They said it was done in whether it's godly or ungodly speed. But the point is that they say it was expedited, and this, they say, affected his due process rights. And two, they say that he was denied an adjournment, and therefore this was constituted a fair process issue. Let me start with the issue of an expedited impeachment. Luckily, again, Sonko raised this exact issue in his impeachment in 2020. He said that the speed within which I was impeached was ungodly, just as the first petitioner is saying this. And the Supreme Court dealt with this thing head on. What does the Supreme Court say in paragraph 135 of the Supreme Court decision? It says, his, and that is Sonko, complaint that the process was expedited can be answered simply with reference to Order 75 of the Senate Standing Orders, as well as Order 72 of the Nairobi City County Assembly Standing Orders, both of which set the timelines within which each step must be taken. No step was taken outside those timelines. Therefore, it means that without belaboring this issue of an expedited impeachment, so long, and we have already seen that the Supreme Court itself has already upheld the constitutionality of standing orders in the context of impeachment, whenever anything has been done within those timelines, there cannot be a complaint that this was an expedited or not. There is a binding precedent in that respect. Let me return to the issue of an adjournment. There are some decisive facts which we are missing the point in this issue. The point is this. There was an application for an adjournment. Most importantly, all the parties have been given an opportunity to canvass this application for adjournment. Compelling reasons have been given by the National Assembly, two of them. One, they say that this particular adjournment that is being sought has the effect of going outside constitutional timelines, which we have already seen the Supreme Court has said that these timelines are sacrosanct. And then they say, the National Assembly also says, no medical proof has been presented to you so that you can exercise your discretion favorably to this adjournment. So there are two compelling arguments that have been given here. The Senate is sitting as a body that must give a decision either way. It gives the decision after according them significant time. The issue was raised at 2:30. They adjourned up to 5. The Speaker actually asked for 5 minutes to write a ruling. He returned, that was 5:35 p.m. if you look at the Hansard. He returned at 6:06. He thought that this was a small issue. He goes and spends 30 minutes. And when he comes back, he actually says that this is a weighty issue that I've had to look into. And he says that I've looked at the application for adjournment. There are things I can do, there are things I cannot do. The only thing I can do in this context of this impeachment is that I can tell the Senate, because it is them to make that decision whether to adjourn or not, that the only thing they can do, they can adjourn up to 19th October 2024, because that is when the 10-day timeline ends. But they cannot adjourn to the 22nd October, that is the Tuesday, that Senior Counsel Paul Mwita had requested for. And therefore, the Speaker says the Senate should have this as a decision. And then the motion is actually moved by the leader of the majority. It is seconded by the leader of the minority. It is defeated. That is the decision that has been made by the Senate on this question. It could have gone either way. They could have agreed to adjourn. They could have refused to adjourn. And then the question that arises here, my lords, is whether dissatisfaction or displeasure with the denial of an adjournment, or whether both parties have been given an opportunity to canvass this issue, constitutes a violation to the right to a fair hearing. My lords, I have a lot of confidence asking this question, because again, this is a question that the Supreme Court itself has posed to itself and answered it. Where has it done that? In the case of Aloche versus Senate and two others, petition E014 of 2025 at paragraph 84. This is what the Supreme Court says, my lords. Lastly, on the right to a fair hearing and Article 50 of the Constitution, we have appreciated the reasoning of the courts below us and the opportunity granted to the appellant to present his case. The appellant was accorded a fair hearing by both courts below. And this is the punchline now that they have been liking. Displeasure with the final orders of a court, in this case, displeasure with the final orders of a Senate, cannot amount to a violation of the right to a fair hearing. Well, just because they're dissatisfied, just because they have displeasure in the Senate's refusal to adjourn, it cannot constitute a violation of the right to a fair trial. Well, if you want to understand this better, this decision could have tilted either way. It could have gone in favor of the adjournment or against the adjournment. If this adjournment had been granted, could the National Assembly be heard before you here today and telling you that because this adjournment was granted, our right to a fair trial was not granted? We very humbly ask that you dismiss this issue. But they also cite two other authorities, the Philippines decision in Sara Duterte and the Onyango law of a court of appeal here. Of course, they cited the Sara Duterte decision in a different context. I think this is my friend Ochel Dudley was filing it in the context of Article 145, but it has very damaging information for them. Because this Sara Duterte decision, and this can be found in pages 706 to 707 of the first petitioner's further list and bundle, defines due process and when an issue of due process can arise. What does the Supreme Court of the Philippines say? Due process is anchored on fairness and equity. And I like that they use the word here, equity, not equality. It is flexible and context dependent, shaped by the circumstances, subject matter, and necessities of the situation. At its core, due process requires notice, hearing, and a fair opportunity to be heard. Well, when you listened to the case of the petitioner presented, all those that it was presented, there was no case that he was not given notice, that he was not given a hearing, that he was not given a fair opportunity to defend his case. In fact, at some point, I think they were very proud of how they had destroyed the National Assembly's chief witness in cross-examination. They are, by their own evidence, they say they were given an opportunity up to the level of being proud of the job that they had done. And the Supreme Court says, a due process issue arises if a person has not been given the opportunity to squarely and intelligently answer the accusations or rebut the evidence presented against them. The simple question to be asked here is, can it be said that the first petitioner was not given an opportunity to squarely and intelligently answer to the other allegation? The answer, my lords, is an rebuttable no. He was given an opportunity. But let me go to this question, to this Onyango law decision. This is good for us because in Onyango law, I think Professor Tom Ojenda made a very good argument in this. What happened in Onyango law? The County Assembly of Kisumu impeached Onyango law and sent him the impeachment motion on WhatsApp at 1:26 p.m. and told him, if you don't want us to go through this impeachment, come to the assembly. Of course, Onyango law tries to go to the assembly. It is blockaded. He cannot go there. He cannot prepare his defense. He cannot file his defense before the county assembly. What happens? At 3 p.m., they have already impeached him. So, two decisive distinguishing features in this case. Onyango law has been served with an impeachment motion at 1:26 p.m. No response has been added there. He's not even appeared before the County Assembly of Kisumu. He has not been heard, he has not tendered his defense, he has been impeached. And therefore the Court of Appeal said in this case that there was no fair notice, no hearing, no fair notice, no fair hearing, no defense tabled or fair opportunity granted to Onyango law. Exactly what Sara Duterte says. But there is something very important that the Court of Appeal says in paragraph 33 of that decision. What does it say? The County Assembly of Kisumu has standing orders, have 7 days within which the impeachment of a speaker should be done. So if they wanted to do this impeachment from 18th September, the Court of Appeal says the last day of this impeachment could have been 25th September 2020. 25th September. And the Court of Appeal says, we think that this was sufficient time to accord the Onyango law a fair hearing. Now, this confirms our argument that the timelines that are already in the Constitution on the impeachment of deputy president or the president are already fair in and of themselves, because they have the opportunity within which the person being impeached can tender their defense and be able to defend themselves with that. And we don't need to belabor that point, because in this case, that is exactly what happened. They filed their defense at the National Assembly, they filed their defense at the Senate within these timelines. So Onyango Olo, viewed in this perspective, is actually favorable to the position advanced by the respondent as opposed to the position advanced by the petitioners.
Want to try and wrap up?
Yes, my lord. Just 10 minutes and then I will conclude. Yes. Yes? My lord, 5 will be. Let me just talk about the substantive validity argument that had been raised. Dr. Budhomi told you that there are only 3 reasons why the first petitioner was impeached. He was impeached because of the inflammatory rhetoric, because that would cause disunity. That is count 1, 5, and 6. He was impeached because of threats to judicial independence, count 4. And lastly, he was impeached because of threats to national security, because this, that is ground 9. And the Senate concluded that his rhetoric of publicly, not any other day, just a day after we had lost innocent lives, he stood before live cameras in front of friends and adversaries of Kenya and publicly told the people that we have a dysfunctional national intelligence service. Well, even if there is questions that we can ask, can we genuinely and in good conscience question the decision of the Senate to say that these utterances made by the second highest office holder, a member of the National Security Council, that he was required to say these things in the secrecy of the about the National Intelligence Service. He said them in public. The senator said, this is gross misconduct. You should not have conducted yourself in this way. Can this honorable court sit and substitute its view and say, no, this was not gross misconduct, this was something else? But if you do that, go back to Sonko, paragraph 117, the Supreme Court says, when you're doing whatever you're doing as a court, you must be careful not to constitute yourself as the county assembly or the Senate, or in this case, National Assembly and Senate. Well, if you go back to exercise a value judgment on these utterances that they have not actually disputed, they agree that these utterances were made, but we want you to say that they were justified, not impeachable conduct as the Senate says. Well, if you do that, you will be going against Sonko decision that tells you that you cannot constitute yourself into an impeachment body. And when you do that, my lord, there will be serious practical consequences. When I listen to Dr. Mudhomi advising his clients who are seeking impeachment services, he tells them that the most important area of impeachment is at the Senate. You need to provide good arguments, you need to provide good evidence, because that's where the grounds are substantiated. My lord, if you agree with the petitioners, I think he'll have to recalibrate his advice. And he'll be telling them, forget about what happens in the Senate. The real impeachment happens in the court. We'll just take this evidence and we are going to persuade the court that whatever the Senate agreed upon is different from what is being said here. And now, lastly, let me talk about the Falafala judgment that was presented by the petitioners. Lord, this judgment is very damaging to their case. Why? The issue in Falafala was that there was a Rule 129I of the National Assembly standing orders that said, when there have been when a special, not an investigative committee has found that there are prima facie grounds to believe that the president has committed an impeachable offense, the National Assembly will vote on that report and determine whether to refer that impeachment motion to the investigating committee. That is how things happen in South Africa. And the Constitutional Court is saying, no, you cannot do this. You cannot subject something which has already found a prima facie ground that the president may have committed an impeachable offense, and you just shut it down by a mere vote. And we think that is a very good argument. You cannot just shut it down by a mere vote. It needs to go to investigation. Lord, that argument is exactly what Ochiel Dudley argued before he under Article 145. He told you. First, Article 145(3)(b) uses the word may because it is mandatory. But if at all it is not mandatory, it is not mandatory in the context of flimsy impeachment grounds. He said, and I used the example that he used, if, for instance, the National Assembly has impeached the president for wearing a yellow shirt, that impeachment is not deserving of going to the investigation. And of course, he has used a very notoriously simple illustration. Well, we have done a lot of impeachment in this country, and there have never been such grounds. But he's exactly introducing Rule 129I of the National Assembly, because what the Senate simply needs to do when they want to deal away with an impeachment motion, they need to say that this is a flimsy impeachment motion. We are not going to go to the investigation. So in this context, this Falafala judgment is against them because it prevents exactly what they have argued against. But the other parts of the Falafala judgment actually confirm that an impeachment is discretionary. If you look at paragraph 50 of the Chief Justice Ma in that decision, it says that even where there have been established grounds of impeachment, the ultimate decision on whether to impeach or not lies in the hands of the National Assembly. Why? Because of the two-thirds vote threshold. And that is exactly what is in our Constitution. But in this case, the Senate can actually find that there is an impeachable offense, but still vote to save that president. And I'm glad that they are the ones who have brought this constitutional court decision, because it ultimately confirms that. And that ultimately confirms Professor Githu Muigai's arguments that this is a political process. Because even where there is evidence that an impeachment offense has been conducted, the Constitution, Article 145(7), gives the Senate the power to actually decide whether they are going to impeach or not to impeach. In other words, I think that is the context within the Falafala judgment is not applicable to the case. And this is the same issue with the Lesotho judgment that they have attached. The Lesotho judgment, the Parliament of Lesotho had voted not to enact a legislation, not to discharge its function. And the court of Lesotho was saying, no, you cannot do that. You have an obligation to enact a legislation. Ochiel Dudley is introducing that interpretation, Article 145(3). He is giving the Senate an easy way within this is my maiden physical appearance from the date of admission, and I thank you for according me the opportunity and the gratitude to listen to me. I'd like to ask Dr. Mudomi and colleague to officially close.
Thank you. Thank you. Before you close, I asked the question yesterday, and you attempted to answer it. Case by case, you have introduced what you call unique nature, which I think the same thing, by case, but in public participation. So this case by case or unique nature, in whose favor should it be? How do you determine case by case or unique nature? Are you, for example, saying that all impeachments are the same? It doesn't matter whether you are a deputy president who came in the same ticket with the president, or whether you are a deputy speaker of a county, or how do we rate or value the unique nature? Who should benefit from the uniqueness of a nature?
Thank you, Lord. If I may answer that. The uniqueness of this process does not favor either side. It favors the constitutional tenets. And that is derived from the Supreme Court decision. The Supreme Court said that this uniqueness has to defer to the tenets. Because if you look at paragraph 125, the Supreme Court is saying that this uniqueness must consider timelines. So what is unique here is the timelines. There are 12 days timelines. If there are 12 days timelines, and the impeachment has to be carried out in that particular case, the uniqueness favors what would be reasonable within 12 days. You cannot weigh it against a 1 year time period and say that if the National Assembly had 1 year, it would have done better or not. It is going to be favored to this timeline.
Is uniqueness only limited to timelines? The unique nature or case by case, is it a submission that is only limited to timelines and nothing else?
In the context of impeachment, my lord, we want to say that unique timelines is the only objective test that we can have in this case. And then the other one now will be subjected within these timelines. We ask, if you had 2 days to carry out public participation, is whatever you did, was it reasonable in the circumstances of this case? And that is the argument that the National Assembly has been attempting to persuade you, that if you look at what we did, there were court orders that came. We had initially done it in 47 counties. Court orders told us to do it within 290 constituencies. We did exactly that within the timelines that we had been given, that we are aware that are fixed timelines. And therefore, within this is reasonable. Because, my lord, if you look into the specific circumstances of each case, then you are risking to go into a subjective test on where you are going now to decide to favor each side or not. And yet you can have a timeline and ask, if this is the timelines, what has been done? Is it reasonable? And remember, the words that the Supreme Court is using here is reasonable. It's not perfect. It's reasonable in the circumstances of not every other impeachment, but in the circumstances of the timelines that are appreciated to each and every impeachment.
Thank you.
Thank you, my lord.
My lord, I would mark the close of the submission by the second interested party. And I wish to state for the record, Kenson has been my pupil, and I'm very proud of it. Thank you.
Thank you.
Dr. Kamoto, what were the timelines? Was it 15 minutes you had requested?
No.
Yes, my lady, it was 1 hour. And it was never challenged at any point. I made that request several, but either way, I will be efficient in the use of time. If I don't need an hour, I will definitely not use an hour.
So you were not assisted by Dr. Nkulu? You were not assisted at all because you said that 98% of your submissions would be covered by him. You were not assisted at all.
Yes, we covered 5%. And I appreciate
My lord, I'm not a 5% man.
Okay, 15%.
My lord, there is a qualification that is important when we come to this particular respondent. This respondent did not file any pleadings in terms of the right affidavit or anything else. And the submissions that we have filed are just 12 pages. There were some grounds, but there are 12 pages of submissions basically saying what everybody else has said. So the big questions would be, how do you summarize 12 pages of submissions double-spaced in 1 hour? Because it's highlighting of submissions. There are 12 pages. There is no affidavit. That's it to the past.
Oh, he has said that he may not need that 1 hour.
Yes, and I also appreciate Mr. Kibe Mungai has given me a book, but I never knew it would come at that cost. He gave me a book, and since he gave me a book, he has consistently opposed my ability to make any submission, to examine. He has become very hostile after donating that book. But without as he may, I will soldier on, and allow me, my Lord, to proceed.
Yeah, proceed, please.
Yes, for the record, my name is Adrian Kamodo. I appear alongside Ms. Katira, for the 10th respondent. And so that there is no controversy about the 6th respondent, I do confirm that I do not appear for the 6th respondent, because in any case the Supreme Court has held that he cannot be subjected to proceedings of this nature, and we would have expected that when leave was granted for amendment, that the petitioners would amend the pleadings accordingly to eliminate the name of the 6th respondent. Now, a lot has been submitted by the respondents who have come before me, and for record purposes, I would say I associate with the submissions of the 1st to 5th respondent, the 7th to 9th, the 16th, and the 2nd interested party. To us, there are two predominant issues that arise from the petition before you, my Lords, my Lady. Notably, is the legitimacy of the impeachment process of the first respondent, and secondly, the propriety of the process that was used to fill the vacancy. Because I won't belabor the points that have already been made, I would first like to state that the impeachment process of a deputy president is wholly contained within the provisions set out at Article 150 and 145. And it is distinguishable from the process of removal of a county governor at Article 181, because the process that leads to impeachment or removal of a deputy president does not require any further legislative action. It is wholesome in nature as per the constitutional provision, meaning that you can use the constitutional provision without making advertence to any other statutory provision or any other legislation. This is because at Article 181, you find the process of the removal of the governor, the removal of a county governor. And it is significant that county governors cannot be impeached. There is no process for impeachment of a county governor. It's only removal that can happen as far as it relates to a county governor. So at Article 181, it provides the mechanism of removal of a county governor from office. And then at Article 2, it states that Parliament shall enact legislation providing for the procedure of removal of a county governor on any of the grounds specified in clauses 1. To date, we have only had successful impeachments of holders of the office of the county of a county governor. So as the court makes its findings on the impeachment in relation to the deputy president, then there will be need to make that distinction and recognize that the Constitution itself is complete in terms of what should guide the whole process of removal of the governor, of the deputy president. Now, for this petition before you to succeed, it required the petitioners to adequately demonstrate that the impeachment process as conducted by Parliament did not follow the provisions of Article 145 and Article 150. Article 145 sets out in detail the process and how it ought to be carried out from the beginning, where it commences with a motion by any member, as long as a guard of support is secured by a member. It is possible to commence the process by enumerating grounds, whether on gross violation of the Constitution, whether on gross misconduct or violation of the constitutional statutes. Once that is done, the next step is that of getting a resolution of two thirds. That was done. So that process has not been in any way challenged, that the numbers were raised. It has also not been alleged that the motion was not transmitted to the Speaker of the Senate within 2 days. It equally has not been shown that the Speaker failed to convene, the Speaker of the Senate failed to convene the Senate within 7 days. What was brought as an issue is that upon the motion being brought to the Senate, it had to be subjected to a committee, to the committee route. But the Constitution at Article 145 is very pertinent, that it's only through a resolution of the Senate that the committee route can be taken. That was attempted, but the resolution didn't pass. So that option was completely extinguished, and what remained was the option of going through the plenary, which proceeded, and a resolution or rather a two-thirds requirement of members of the Senate was met as required for purposes of passing a particular charge. And of course, there were several charges that there were actually 5 charges that were approved in that regard. The other issues that have been raised variously by the petitioners relate to the speed at which the process was carried out. Ordinarily, the Constitution provides the timelines for each and every act that it requires done. But even where it doesn't provide for a particular timeline, Article 259(8) provides that any act required under the Constitution must be done without unreasonable delay and as often as occasion arises. The Constitution does not in any way impose a speed limit in terms of the discharge of the affairs of any constitutional organ. So if a particular motion has been approved by the National Assembly and is required to be transmitted to the Senate, it can be transmitted anytime, day or night. Interestingly, whereas the petitioners have found fault with the speed at which the various arms and organs of Parliament operated, they have also not been conscious that they also moved at breakneck speed to file a petition when they were dissatisfied about the process. You will see that on 18 October 2024, there was a petition that was filed and supported by an affidavit sworn by the first petitioner, Rigathi Gachagua, on the night of 17th October. And at paragraph 28, the deponent states that I confirm that due to the urgency of the matter and prevailing circumstances, I sign this affidavit on the hospital bed at Karen Hospital in Nairobi in the presence of the Commissioner for Health, as I continue to be admitted following the doctor's advice as reported in the Daily Nation, and a link has been put. So, this, interestingly, my lord, my lady, you will find is the same person who the Senate was told at 2:30 p.m., and that is in page 7 of the Hansard, that he was extremely sick and hospitalized. But you'll see at night he's signing affidavits. On another note, the counsel who appeared to represent him in the National Assembly lost contact, as they confirmed to the Senate. They couldn't get instructions from the first petitioner, but at night, the petitioner...
My Lord, just on the guidance, I'm just wondering, my Lord, whether my learned friend Mr. Kamoto can comment on an affidavit when he has not responded to it, because all what he filed, as previously indicated, was were grounds of opposition. Can he comment on an affidavit when he has not responded?
Well, the question is, do you make those suggestions outside an affidavit from the bank? Or would you like to be where Dr. Kikunya was yesterday?
My Lord, I'm not making any depositions. I am dealing with the documents that have been placed before the court. So, I know it's a distraction. I have done a lot of litigation with Mr. Degwajiro, and I know he likes to interfere with my flow of thoughts through such disruptions, but I will cope. So, my Lord, my lady, what we are observing is that the counsel that represented the first petitioner and the Senate, and notably the eminent senior counsel Paul Muite and distinguished former member, long-serving member of Kikuyu constituency, was not able to reach the first petitioner during the Senate hearing. But at night, another counsel was instructed. So this affidavit is drawn by the firm of Kamoto, Jomo and Company advocates, meaning that unknowingly, when senior counsel Paul Muite was hunting down for his client, the client was engaging another counsel. So I empathize that senior counsel had to be short-changed at night. But now, because they have raised the issue about the speed, then what is good for the goose is definitely good for the gander. If the Senate moved with speed and the petition has moved with the speed, then they are at an equilibrium. There is a draw. So no one can pose an issue as to the manner in which the process was carried out. There is an issue that was raised about fair trial, and reference was made about the right to appear and be represented by the council. It has not been shown that the right to appear was denied. In fact, there was appearance all through by the first petitioner and his counsel up to the point when the first petitioner went off the radar. All through, there was representation, and as has been submitted, the prejudice that was suffered for non-appearance of the first petitioner at the final stretch was to the prosecutors of the motion, of the impeachment motion, because they were not able to test the veracity of the evidence. On public participation, it is clear there is no denial that the Senate, the National Assembly, and this is admitted in the affidavit shown by the first petition on 18th October at various paragraphs from paragraph from paragraph 13 of that affidavit. The first petitioner indicates that there was a notice on public participation. He also cites an order that was issued by the Kerugoya High Court, which was complied with, and had it not been complied with, if there was an issue about non-compliance, then you would have been shown a committal proceedings for contempt. So it means there was full compliance in terms of the court annexed public participation that was guided by the High Court sitting at Kerugoya. And once the National Assembly had done the public participation, as notable from Article 118, the reference is made to Parliament in terms of public access and participation. If one House of Parliament has undertaken public participation, then it is impossible to say that Parliament has not undertaken public participation, because the conduct is perceived to be of a joint venture of an impeachment process. A question would arise if insistence was to be made that for every trial process that there be public participation. The next challenge that would be directed by the petitioners would be to the determination of the courts. They would say that the process, like the one we are doing here, if a judgment is issued, they will challenge the judgment and say that there was no public participation. So to the mind of the petitioners, they believe that in every case, even when it is going to render absurd outcomes, that public participation should be undertaken blindly. But we submit that public participation is not a process that is supposed to be done outside the confines of logic. It must be done, but it must be undertaken within parameters of rationality, such that nothing will then arise from the allegation that public participation was not conducted. It did not cover everyone. Even in Parliament, when debate is happening, not all members get an opportunity to speak to a particular motion. There is control in terms of debate, control in terms of time, because time is not infinite. But at some point, a decision has to be made in the manner prescribed by the Constitution by way of voting, as provided in Article 122, where it states that except otherwise, as provided in this Constitution, any question proposed for decision in either House of Parliament shall be determined by a majority of the members in that House present and voting. Just the same way litigation terminates at some point, even debate in the House has to terminate, and decisions must be taken by way of voting. It was also the petitioner's submissions that impeachment should be a matter of last resort. On this, position, we find the position taken by the petitioners to be outrageous, because you are told a person who is alleged to have grossly misconducted himself, to have violated national and international law, to have grossly violated the Constitution, should be allowed to stay in office. So you are told somebody who is pilfering public resources, for instance, should be allowed to continue stealing, and then action should only be taken as a last resort when he has stolen everything. That is the context within which the argument of the petitioners would be perceived. And that, again, would be completely absurd. So for us, we submit that impeachment process is a fast and immediate result when grounds are available for purposes of moving the process of impeachment. Now, my lords, my ladies, you are also told that the reason, and this is born in the affidavit of the first petitioner at paragraph 8F, whereby it is deponed that the National Assembly, the second respondent herein, prosecuted proceedings on the basis that I offended the President rather than the Constitution and the law. The object of impeachment exercise appears to have been to please the President rather than examine fidelity to the Constitution. This position is completely defied by the outcome of the process of impeachment. All the grounds that had any touch on the executive or where the President was mentioned, they all collapsed. And this is typical of ground number one, ground number two, gross violation of Article 147, 1 and 152, 1 of the Constitution by undermining the President and the Cabinet and effective discharge of the national government's executive mandates. So that one failed. But to the mind of the first petitioner, it is the President who was after him. We go then also to ground number 10. Ground number 10 was gross misconduct by openly or publicly insubordinating the President, who is the head of state and government.
Mr. Doctor, did your client file a replying affidavit?
He did not file. I'm reading the answer report.
So what response did your client file? Because I'm seeing you are going too much into factual issues, and I just want to clarify whether you controverted those facts in a replying affidavit.
My Lord, I'm not controverting any facts. I'm just drawing observations from facts as they are.
So I mean, just ask, did your client file a replying affidavit?
No, he did not file.
Okay.
So, my lord, my lady, I was just indicating that on those grounds where association could have been drawn to create an impression as made by the first petitioner that the process was done for purposes of appeasing the president, then holds no water to that extent. My lord, again, that affidavit, you will find in that affidavit at paragraph 11, the ground number 7 has been attacked at length.
Which affidavit is this?
Affidavit of the first petitioner, the one sworn on 18th October 2024.
Yes, that is the exact issue I raised. You are responding to averments in an affidavit in a situation where your client has not filed a public affidavit. Do you think that's proper?
Yes, why not? Because I am not challenging the. These are facts. These are documents, and my lord, the petitioners have even brought books, and they have been applicable.
Yes, but you see, Daktari, you have to choose. When you are served with an affidavit, you have to choose. If you decide to controvert the factual affirmance in an affidavit, is through another affidavit. If you decide to file a grounds, then you are limiting yourself to issues of law. So you may need to look at the approach you're taking.
I'm well guided here, my lord. Yeah, but for purposes of these submissions, I am not controverting. I'm just making any observations. As they are. Without estimate, we also want to note that the issues that have been raised in that affidavit point to the position that we have all through been advancing. In other words, this affidavit and petition for that matter has fallen on its own sword because it has provided evidence that is in support of the respondent's view that the process of impeachment was undertaken in accordance with the law. I now shift to the next issue that arose, which now relates to the filling of the vacancy that arose.
Dr. Kamoto.
Yes, ma'am.
You filed submissions.
Yes, ma'am.
How many pages are those submissions? I would give you opportunity to read those submissions verbatim, because we are highlighting submissions, and we understand what we mean by highlighting submissions. The maximum time we can give you is to read them verbatim.
Yes, what I've just finished is just expounding because the issues there, you find the first issue that we have addressed is brought out the procedure for impeachment of the deputy president. Then we have also talked about the standard of proof, whether it was met. Then whether the court can interfere with the process, whether the process of appointing. So basically expounding on the issues. It's only that when we are submitting, doing written submissions, unlike our counterparts, we are not too verbose. We just hit straight on the issue. And that's why they are counting the pages of my submissions when the game was not about the counting of pages. So I deem it unfair that the counsel for the petitioners would want to muzzle the voice of the 10th respondent. But my lord, I will be brief. I have now moved to that second issue about what ought to have been the process of filling the vacancy once the vacancy arose. And Article 149, which we have already observed, is wholesome enough. It's clear that within 14 days after the vacancy in the office of the Deputy President arises, the President is to nominate a person to fill that vacancy. Was that done? And within the time frame, yes, it was done. And as properly distinguished by the learned Senior Counsel, Dr. Mudomi, the process of filling the vacancy under Article 149 is different from that at the general election time, which would require that some other processes be undertaken. So what is provided here is the name to be provided and to be voted for within 60 days. Was it done? We submit it was done in utmost compliance with the provisions of the Constitution, and that being the case, then the whole of the petitions, all the consolidated petitions, would fail to raise any material issue that would warrant the court to interfere or disturb the position taken by the Parliament in terms of impeaching the first petitioner. So that we draw to a close, I will invite Ms. Kasera to summarize on our position.
Through the permission, Doctor, just a minute, through the permission of the presiding judge, I need a clarification of your thoughts on something which you've talked about. You indicated that in the Constitution, a governor is removed and a president is impeached, and that the two are different. Now, apart from the diction, apart from the use of the words governor and president, and the processes, the differences in the processes, do you think there is any difference on the effect of either removal or impeachment?
The effect would be very remote, because even the wording of 181 is only that it removes one of the grounds, the ones for physical incapacity. It treats it as it only has all those grounds actually condensed into one. The one for removal of the Deputy President, you'll find removal is on physical incapacity, the first ground, and then that's removal, and then impeachment is where you have the gross violation of the Constitution, gross misconduct, serious reasons to believe that there has been a crime committed at national or international law.
So in terms of the effects, we agree that there may be no such difference.
There would be a difference, because the other one, at Article 81, it has an added provision that Parliament is to register for the process at Article 181. But for purposes of removal of Deputy President, there is no requirement for further legislative action or intervention. It is self-contained, meaning that you just look at the Constitution. You are not directed to look elsewhere. So the process for impeachment of a Deputy President is as contained in the Constitution. There is no requirement to make reference to any legislation.
That is in terms of the process, isn't it?
Correct, my lord.
But my inquiry was limited to the effect, whether you think there's a difference in the effect. After you're being removed or impeached, are you on the same platform, or do you stand on different ground?
You stand on the same platform because as per Article 75, you cannot hold office. You cannot hold office in future.
Okay, thank you so much, Dr. I appreciate it. Thanks.
Thank you, ma'am.
My lords and ladies, Ms. Gadira, I appear alongside my senior Dr. Kamodo for the 10 respondents. I will only take 5 minutes of your time to highlight the issues. My lords and ladies, the process of impeachment is in 2 stages. One before the Senate, one before the National Assembly, then the Senate. And it is a discretionary process, a political discretionary process. Thank you, Senior Counsel. And as held by the Supreme Court, this court will be very reluctant to interfere with the discretion of the Parliament under the political question doctrine. The question then is, under what circumstances can a court of law interfere with the discretion of Parliament? And the answer is in 2 decisions, the Sonko decision and the Justice Kariuki Mate decision that has been highly referred to by both sides of this petition. And for the court to interfere with the discretion of Parliament, the same has to be on question of whether or not the Constitution has been breached. Specifically on what rights of the petitioner were infringed by Parliament during the 2 stages of impeachment. So the question that we therefore ask, which is the question that the court will have to determine, is what rights was the petitioner and the first petitioner entitled to during the 2 processes that were infringed. We highlight that majorly there were 3 rights. We have the right to a fair hearing under Article 10, the right to a fair administrative action under Article 47, and the public participation highlighted under Article 10 and the other articles of the Constitution. Looking at the right to a fair hearing, the same has been highlighted before the National Assembly, the specific stages, and what amounted to the right to a fair hearing, and who had the right, and if at all it was infringed, on whose part. In this case, the right to a fair hearing was infringed on the part of the Senate and the National Assembly because we were not given a chance to cross-examine the first petitioner on the evidence that he had presented before the two houses. Meaning, on the part of the first petitioner, he enjoyed the right. Specifically, under the sub-article 2 of the Article 50, different principles are provided therein to adduce evidence which he did, to challenge evidence which he did, and ample time to prepare, which was provided to him. On the right to a fair administrative action, the threshold is provided under the Act itself. There has to be adequate notice. Was there one? It's been submitted, and it is on record from the Hansard that there is a notice that was provided to the first petitioner to appear before the National Assembly, to appear before the Senate, and the charges that were advanced against him were provided to him for him to answer. On the second principle is the reasonable opportunity to be heard and make representation on the charges advanced against him, which he did. There's the legal representation, which he enjoyed. It's been heavily submitted that he had the senior counsels who were present, and the petitioner was also present during the proceedings. There's a principle of expeditious and without delay. The decisions were made within timelines, within the constitutional timeline. And the decisions have to be lawful and procedurally fair, which is a principle that has already been submitted on. I do not wish to rehash on the same. On the public participation, my lords and ladies, I fully associate myself with the submissions made by my seniors, Mr. Dr. Mudomi Diankonu, my teacher, Mr. Kipkosgei, Professor Ojeda, and Ms. Tanji, on the specific aspects of the public participation in the National Assembly and in the Senate. The threshold that is required in the BAT case, which was met. And with that, my lords and ladies, I submit that the rights that were to be enjoyed by the first petitioner during the whole process in the 2 stages were present, were enjoyed, and if any violation occurred, it was on the part of the respondents and not the first petitioner. And on those grounds, the 10th respondent submits that the petitioner has no merit and should be dismissed. Thank you, my lords and ladies.
Thank you.
My Lord, that should mark the end of submissions on the part of the respondents and the interested parties that are opposed to the petition.
Thank you. Why is Mr. Umuke sitting beside?
I had warned him he was in hostile territory, but he's a good friend of mine.
Your Lordship, when you sit with your teacher, you cannot be in any other territory other than your teacher. And I needed to talk to him also that his tone was too harsh when he presented his submission, and I guided him also a little bit as a student.
Thank you. So, let's just know how many are speaking this side.
My Lord, for the first petitioner,
yes.
My name is Ochiel Dake. It falls on me to take the rejoinder for the first petitioner. My learned friend, Mr. Mashal, will join me on that date.
No problem. Like how long?
And the senior counsel will wrap up. My Lord, we are requesting for about an hour if the court can.
For everybody?
Yes, yes, for
the entire team?
No. Shared. The 3 of us, the first petitioner's team.
Shared 1 hour?
Yes. Yes.
And my Lord, as indicated before, we still online. Yes, still okay.
My Lord, I am still in line too. My Lord, Jeremiah, I was requesting for only 10 minutes to respond to the issues that Council raised pertaining my character.
We had said that parties who wish to rejoin could file submissions.
My Lord, I understand that you had given instructions. My colleague, Muge, took the directions that I was to respond specifically on the issues pertaining my character. My Lord, as you can see, the cameras are on. You can imagine the number of people that were watching as I was painted as a sort of warlord before this bench. It is critical, my Lord.
My Lord, that's not an issue that is available to do in a reply. A reply is traditionally on matters of law. Our character or lack of it, it's not really something that would be spoken to. I was also going to suggest, my Lord, we have various biologies. If we could perhaps have a brief lunch break, then people can replenish their sugar levels. Then if necessary, we can have even an extended afternoon, as long as we're sure we close this today.
My Lord, while my senior may not care for his character, I do care for mine.
My Lord, I would
plead with this court to take into account that our opponents responded to the petitioner's case orally in court, together with the vote of the public opinion. All we are saying is that, yes, let us shorten our respective replies to those responses that were made orally in court. We will shorten, but allow us to do so orally in open court. Thank you.
We'll give you, because we are not obliged to explain to you our circumstances also, which apparently you don't want to hear or to know about. I'll give you 1.5 hours to respond orally to the responses. And we are not going for a break because we don't have that time.
Thank you, my lord.
Please proceed.
My name is Ochiel Gadle, and I rise to make a rejoinder. Keeping first things first, my lord, let me first of all briefly dispense with 3 matters of first principles that came from the submissions by my learned friends, senior counsels, Githu Muigai and Muthoni Kiankolo. My lord, let's face it, the suggestion by senior counsel, Dr. Kiankolo and Professor Muigai, that when you are hearing us on the interlocutory matters, you, with finality, decided the meaning of Article 145 is a suggestion that is repugnant to justice and morality. My lord, that suggestion that an interlocutory court can determine disputed matters at that stage defies the logic of Uhuru Highway Development versus Central Bank of Kenya, holding that opinions expressed on the merits of a case at the interlocutory stage do not bind the trial court when hearing the matter of the merits. The trial court, I quote, is bound to ignore the findings and to apply its mind afresh to the decision of the issue. It doesn't matter whether the suggestions come from the Court of Appeal or the Supreme Court on interlocutory matters. You must apply yourself and mean. The other matter of first principle came from Professor Githu Muigai on his ambivalent stand on whether you should intervene or not. At some point he said there's a dilemma. If you intervene, it's bad. If you don't intervene, it's bad. My learned friend, Mr. Gumbo, suggested that you await the voters' help in 2027, determining whether the Article 145(1) threshold was met, even though it uses legal terms: gross misconduct, serious grounds, and gross violation. Lord, on that dilemma, there's Cohen versus Virginia declaring it, and I quote again, a treason to the Constitution for a court to decline a jurisdiction it has, much as it is a treason to the Constitution to take a jurisdiction you lack. My lord, unlike Parliament, a court cannot avoid a decision because it approaches the boundaries of the Constitution due to political questions. My lord, the last matter of first principles that I turn my mind to is Professor Githu's invocation of Mong'are versus Attorney General concerning Professor Odek's warning about history. My lord, when that case was cited, I wonder, why is this case so fundamentally, why does it have such a fundamental principle, but it's so rarely cited? Then I went and checked on Kenya law. Mong'are versus Attorney General has been cited 7 times in 12 years. It's a 24th January 2014 case, and obiter dictum responding to the submissions of Nzamba Kitonga, senior counsel, Professor Odek chooses to say something about the use of historical material in constitutional interpretation. But a month later, a month after Mong'are Court of Appeal, the Supreme Court decided, read the matter of Kenya National Commission of Human Rights, and at paragraph 26 of Re KNCHR, the Supreme Court accepted the same arguments that Odek J in his obiter had rejected in Mongare. And the Supreme Court mainstreamed the use of history as a part of the holistic interpretation of our Constitution. And so, my Lord, you must go back to Bomas, go back to the Kilifi draft, go back to the Wako draft, and see what the debate was about. 9 months after Mongare, in the vetting board case, where the Supreme Court cites Mongare for the reasons, it impliedly again overrules the Odek's warning about history. When we are told to interpret the Constitution like a will, like a contract, like a mortgage, a document that tells us that I am always speaking, the Constitution is always speaking. You must interpret it in context. You must interpret it purposively. You must interpret it holistically. You must consider the history, the issue about the place of the deputy president, the concern that I told you about in the CKRC for mechanisms that make sure that impeachment does not become a tool for political maneuvering, but remains a sacrosanct constitutional process. But in the alternative, even if Odek's obiter were the ratio desideri, this case meets both limbs of the test that he has at paragraph 132. He says that for a court to use the travaux preparatoire, there must be two grounds met. One, the material must be publicly accessible. And two, the travaux must clearly and indisputably point to a definitive legislative intention. One, publicly accessible material. Two, that using the travaux would clearly and indisputably resolve the dispute. This case meets both limbs of that test. One, my former employers, Kenya Law and Katiba Institute, have both ensured that these draft constitutions are publicly accessible. If you go to Kenya Law, if you go to Katiba Institute website, you'll find the Bomas guide and other draft constitutional instruments. Number two, looking at those drafts, you'll find that this committee, my Lord, it's not about the shall or the may. You're making a constitution. You're not debating verbs, modal verbs, auxiliary verbs. Do we use may or shall? It's about the structures, the processes. You're debating which body should investigate, who should appoint. So that's why at some point it is the speaker to appoint. Then at some point it is the Senate to appoint this committee. It was about who appoints it. Then at some point the National Assembly say the National Assembly will appoint. So when you look at the historical material, as you must, you will find that it resolves that issue. And on the issue of Article 145, there was a landslide of constitutional magnitude triggered on the 9th of October 2024. But not assume that the option of plenary was there, was available. It was a constitutional choice. It is not. It is not available. But assume it was available. Where is the Senate resolution to investigate this matter of plenary? The motion that was passed, the motion that no one found it in them to second, was for this special committee. That motion fails. But this impeachment, the inquiet impeachment, lapsed at that point. It died at the point of the failure to second the special committee motion. The Speaker does not direct another motion for plenary, assuming plenary were an option available. The Speaker directs that the motion to form the special committee has failed. Pages 48 to 52, Speaker, affidavit of Jeremiah again. Senate says we are going to investigate this, to hear in fact. It doesn't use the word investigate, which is a constitutional word for that stage. It says we are going to hear this by plenary, like we do for governors. My Lord, we agree with Dr. Kamoto that the procedure for governance is different from the procedure for the Deputy President. In my opening remarks, I told you that the two articles are being debated differently, so that we agree with them fully that Article 145 comes complete. My learned friend and younger brother, Mr. Mutegia, suggested to you that there's no difference. My Lord, if there were no difference, these makers of the Constitution were legislators, including our team leader, Senior Counsel Paul Mwite. And they sat in plenary at the CKRC. They also sat in committees, in the working groups. They didn't know the difference between plenary and committee, so that they could use, by using the word may, imply that you can read the words plenary into that article. My Lord, by refusing to form this special committee, Senate moved this process from Article 145(2), when the motion came in, all the way to Article 145(7). My Lord, if you look at Article 145(4), the special committee must investigate the allegations and must do so in 10 days. The Speaker of the Senate collapses those 10 days into 2 sittings, 16 and 17, and they are done. So they investigate there, and then they sit over their own investigations. My Lord, Article 145(5) requires a hearing. You must be heard during that investigation over the 10 days. That was taken away. Article 145(6) requires a report indicating if or not the allegations have been substantiated. Where is that report before you? That report is not there.
Article 1?
45(6) requires the special committee, not plenary, to indicate if or not the allegations have been substantiated. To report to the Senate is a word the Constitution uses. And my Lord, even if the 10 days borrowed from Article 145(3) applied to the plenary sitting, the Speaker and Senators denied the Deputy President the balance of the benefit of those 10 days. My Lord, Dr. Thiankolu told you about the parade of horribles, the fear of constitutional processes without timelines. Lord, Article 259(8) of the Constitution tells us that where no specific time is provided, then you need to perform the function without unreasonable delay. And Rule 12 says that after the committee reports, my Lord, and Senate is now hearing the Deputy President at the second hearing. That article has 2 hearings. 145(4) is heard in investigations for 10 days. 145(6) is heard on his defense to the charges that have been substantiated. 2 hearings. Now, the point I was making is that, yes, about Rule 12. My Lord, Rule 12 said that the second stage hearing, the hearing will be held from day to day until the Senate votes on the matter. Well, that's language you are familiar with. The court has heard us from day to day until the conclusion of this matter today. So the parade of horribles is really, my Lord, nowhere. And my Lord, because of that cascading failure, the failure to form a crucial committee that we can see in all constitutional drafts, that we can see in all democratic countries. The inquiry panel, you've been addressed on Falafala, but they don't have to tell you about that there's a mandatory inquiry panel in South Africa that also investigates. The House Judiciary Committee that also investigates in the US. My Lord, not to rehash my arguments, and also coming to Onyango law, the respondents have tried.
You have a written rejoinder. You can give us this after.
My Lord, I've already noted what the court wants me to do, and I'll do it. My Lord, my respondents could not distinguish Onyango law. If Onyango law was about unfair hearing, so is this case. And on the Duterte case, which was cited to you by everyone, My Lord, all 13 judges in Duterte take up jurisdiction and nullify the impeachment. But Duterte is cited to you as saying that he should not take jurisdiction. That is a political case. My Lord, if you look at the lead judgment of Lionel, he says that it's a legal, political, and constitutional procedure. It is not purely political. It must comply with the Constitution. And that, obviously, sham complaints must be dismissed immediately. This involved sham complaints that needed to be dismissed immediately. My Lord, the decision that is cited to you is the decision of Hernando J., one of the judges who write separate opinions, and it is his obiter dictum. His ratio desidendi concurs with the majority, but the court not only has jurisdiction, but that impeachment is also a legal process. My Lord, what they cite to you as the court's decision is the court's framing of issues. The court is saying, here in this case, you have challenged how this was done. We will not tell Senate how to handle the merits. We will not speak about the merits. It was not the ratio of Hernando J. in the Duterte case. Lord, the jurisprudential gods must be crazy. On 8th of May 2026, while my learned friend, Professor Gilmude, took the podium to tell you that you should shirk jurisdiction, the EFF court was delivering its decision asserting jurisdiction, both over the process and over the vote of the National Assembly. That's precisely what you're told not to do. You're told don't substitute your judgment over the vote, majoritarian vote of Parliament. Well, that decision, you won't believe it, at paragraph 49, also interpreted the word may. Maya Chief Justice in the EFF case, the Falafala judgment, and she says, I quote, that may does not always imply the existence of a discretion. My Lord, Maya also says at paragraph 38 that the Constitution itself requires judicial intervention by the court. My Lord, 3 months before Maya, the Lesotho case that has been cited to you also took up jurisdiction over Parliament and directed Parliament to enact the legislation. And my Lord, how ironical the law is sometimes. The word may also came up in that decision. The word that you're now being told means discretion in all cases, even if interpreting it as discretionary leads to absurdities of untold proportions. In that case, the Lesotho case, Mojapela case, my Lord, the court held that although may generally connotes discretion, you must look at its purpose. Remember here you're being told that the Constitution is a dead letter law. Don't look at its intention. Don't look at its purpose. Interpret it like a mortgage. My Lord, my learned friend, Dr. Piankolu, took the stand and told you that no country has ever interpreted may to mean shall. He cited Australia. And I wondered if he looked at our further bundle of authorities. We have a case from Australia saying the same thing that our court has also said, that whether may is permissive or mandatory depends on the context. My Lord, we've cited to you in our further bundle the case of Sony Holdings versus Registrar of Trademarks, Court of Appeal, 2015, Kenya law, National Assembly versus Sokoiti, Court of Appeal, 2024, Kenya law, Peter Muturi Njuguna versus Kenya Wildlife Service, 2017, Court of Appeal, Mayor Agri-Traders versus EcoBank Kenya Limited, Court of Appeal, 2020. In short, we've cited to you purely Court of Appeal decisions, saying that whether may is discretionary or mandatory depends on the context. And also look at Article 145, make the may discretionary, and look at the cascading failure. Look at Article 145 3b, make the May as mandatory. A committee must investigate these charges and look at the effect. My Lord, that article is simply sequential. National Assembly cites to you the authority of Helen Santaki, saying that the semicolon coordinates related sentences which belong together, yet are slightly separate. There is not only a semicolon, but also an and. So that authority cited by the National Assembly applies even with greater force here. My Lord, that article just says that after you've done 145.3a, do the 145.3b, the and. Professor Ojenda did not even mention that article once in his submission. Allow me to move to another issue, and that is the issue of, in order to accept the respondent submissions, you must, using the pens you now have, my Lord, pick up Article 145, and wherever it says special committee, you must add the words or in plenary. So when it says the Senate the Senate by resolution may appoint a committee of 11, you must say or plenary. May appoint the House in plenary or the special committee. We say the special committee shall investigate. You must add there, my Lord, or the House in plenary, the committee or the House in plenary. Where it says the special committee shall hear the Deputy President during the investigations for 10 days, you must say the House in plenary or the special committee of 11. My Lord, Professor Ojenda substituted that special committee of 11 with the House sitting in plenary as 68 members. My Lord, there is a may in Article 168.8 of the Constitution, and this is to show that it depends on context. Professor Dr. Kenkolo, my Lord, maybe that's a prophecy, suggested that, if you interpret the Article 145 may as discretionary, then you must do that in every case where the may appears. There's a may in Article 168.8, my Lord. That may says that a judge aggrieved may appeal the tribunal's decision to the Supreme Court of Kenya. My Lord, we'd laugh out of town. We'd take a moment to laugh if anyone suggested that because that may is there, it is discretionary, and a judge aggrieved by the tribunal's decision to remove them can come to the High Court, can go to the ELRC, can go to the Court of Appeal. Why not? Yes, there's a may there. My Lord, may in law is not always discretionary. Our high school grammar teachers told us, yes, it's discretionary. My Lord, they were not teaching us legal language or interpretation. There's another may in Article 163.6 of the Constitution. Now that may is discretionary. It's about the jurisdiction of the Supreme Court. My Lord, the case from Lesotho told us that may can confer a discretion or can confer a duty and a power. So the Supreme Court has discretion to give advisory opinions under the may in Article 163.6. But it has a duty and a power under Article 168.8 to hear judges aggrieved by the decision to remove them. My Lord, my last issue is this one, and this is about the drafting history of Article 145.3b and the way it conclusively addresses this dispute. My Lord, earlier drafts of Article 145.3b used a conditional if. They say if a motion passes, the motion comes, then senators hear it. Dr. Kamodo told you that they have discretion. They must not always impeach. They hear the motion. They find it's a blue shoes motion. They vote the motion down, like the one that died on 9th October 2024. The impeachment should have died there. They don't have to appoint the special committee. Why? Because they exercise the political power you told they will to defeat the impeachment motion. It wasn't intended that every impeachment must run all the way to the end and result in an impeachment. Remember, there's 145(1) that has threshold. The senators look at the threshold. They say there's nothing here. Wearing a blue coat is not an impeachable offense. So this motion, we are defeating it. My Lord, earlier drafts, before the politicians came in, used if the motion passes, and then it said the speaker shall. So they're trying to change, okay, speaker alone, you can't do that. Let's bring it to the Senate. So the next draft says, if the motion passes, the Senate shall. About 3 drafts say that. We've given them to you. And then, my Lord, after the failed referendum, negotiations are going on. Again, it's in our further bundle. The language then changes and begins to say, upon hearing the charges. At the end of that, the National Assembly took up this role, and they harmonized. The Committee of Experts brings it back to the Senate, and then it comes back to the main, which is there, my Lord. Lord, just to conclude, looking at that draft, it is clear that the main refers to the passage of the motion. If the motion passes, the Senate must then appoint the special committee. My Lord, I close with the relevance of gubernatorial cases, and I rely on the submissions by Dr. Kamoda on that. But those two processes are entirely different. At any rate, in Sonko, this court warned about the potential for a plenary investigation to be fused into a mash that becomes a lynching mob. And no one told you about the Senate digest. None of them, not my friend Mukele Moni, not Ms. Ranji, not Professor Ojeda. The Senate, in its digest, which we place on record, recognizes this warning. My Lord, this petition leads to an inevitable outcome, and it's being allowed, my Lord. My Lord, allow me to close by a quote by Shakespeare, that looking at all these, what has happened here, the substantive, the procedural violations, Rigathi Gachagua was a man more sinned against than sinning, like King Lear in Shakespeare. My Lord, may I request you to invite my learned friend, Mr. Mashawa.
How much time did it take? 15.
30 minutes. Yeah, 30 minutes to go.
Mr. Machara, you asked for 1 hour. You have done 30 minutes.
Yes, I'll be very brief. I go straight to deal with summary matters so as not to waste time. The respondents have spent 60 to 70% of their time trying to persuade you that you have no jurisdiction. In your ruling, dated the 31st of October 2024, at paragraphs 84 to 117, you dealt exhaustively with that question. You emphatically found, and I in particular refer you to paragraph 116 of your ruling, that you have jurisdiction and that the questions before you are both political questions and constitutional questions. In the said ruling, in the paragraphs subjected to you, you made reference to a case that has been cited numerous times by the respondents, but almost on all occasions by misquoting it. I have come with an extra copy just so that we do this quickly. This is the case of Sonko Supreme Court. I have 3 copies here for the court to have a look at so that I can go quickly through this. What the court did, and you did, and you identified this in the ruling I've just referred you to, it said it was making this decision to provide guidance on future impeachments. And at paragraph 161, my lords and ladyship, which we'll find at page 43, I came with a copy for all judges. At paragraph 161, this is what the court says. The principles governing the process of impeachment of removal of a county governor that flow from this decision may be summarized as follows. They begin, and this is in parliamentaria mutatis mutandis. I'm not sure what are the Latin words there for this. It's on all fours with the impeachment of a president or deputy president. 1. All sovereign power belongs to the people of Kenya to be exercised directly or through their elected representatives at the national and county level and state organs. Then they say the spheres for jurisdiction of removal are at county assembly and at the Senate. And this is now where we begin getting into the issues you've been told here. Where it is alleged that any of the two organs has failed to act in accordance with the Constitution or in conformity with the law and principles of natural justice, the courts are bound to review their decisions. So you have the power to review the decision of the National Assembly, to review the decision of the Senate. And your jurisdiction and the remedies available are at Article 23 and at Section 11 of the Fair Administrative Action Act. But as to the most vexing question, which I think all my colleagues have spent 60 to 70% of their time dealing with, this is item 4. The removal of a governor is both a constitutional and political process. This is what you found in your ruling. The mandate of the courts is restricted by the doctrine of separation of powers to determine whether individual rights, dignity, and fundamental freedoms have been preserved and protected in the process without usurping the powers. And they did so. They explained that it is possible to do the two of them. You can examine what happened without, as a mischaracterization appeared here yesterday, sitting in the place of the Senate. You can do both. They then say, during the process of removal, the right to fair administrative action under Article 47 and the right to fair hearing under Article 50 of the Constitution all accrue to the governor. Now, when you review Article 47 and the legislation that flows from it, which is the Fair Administrative Action Act, you will find a criteria requiring certain things to be done at Section 5 of that statute. Amongst the things, and the word it uses, when you go to the definition of what administrative action is in the statute, it includes the words quasi-judicial, which is something we all agree here. It is part of a jurisdiction, I believe, under Article 165, when you supervise quasi-judicial bodies. And so you have the power to review all this. And I say this in particular to a question I'll be returning to very shortly. There is equivocation on the part of the respondents as to whether the Senate was required to do public participation or not. And they were, because the Fair Administrative Action Act deals with decisions. The removal of the deputy president is a decision. And so the requirement for public participation, both under Article 10, Article 118, and Section 5 of the Fair Administrative Action Act, applies to both the National Assembly, because the National Assembly, I believe under Article 95 it is, just initiates the removal. The Senate concludes the removal. Those are two distinct decisions. That's number one. Number two, the Senate and the National Assembly are two distinct bodies. The Senate cannot say it delegated that function to the National Assembly for a very good reason. The National Assembly did not carry out public participation with the benefit, among many other wrong things they did, with the benefit of what the Deputy President was saying. And I'll be coming to explain to you why that is important. Number 6, public participation. Yes, this is the one. Public participation is an integral element of the process of removal of a state officer from office. Integral. Integral is the direct opposite of what you are told. You are told it is to inform. You are told it is to touch base. I think those are the words used by my good friend Mr. Michelle. It is to touch base. That's why you have public participation. The Court of Appeal has said it is integral. That's the word it uses. And then, ground number 8, the grounds for impeachment and removal from office must be substantiated. The standard of proof is intermediate, that is, above a balance of probability, but below all reasonable doubt, and the proof of any one of the charges is sufficient. Now, my good friend, Professor Ojenda, yesterday, and I'm thankful to him, I think, for his candidness. He said the grounds for removal are any grounds, I think the word he used, even a silly ground, I'm quoting him directly, even a silly ground is sufficient. That's what he said. And I think it's important to take him seriously because apart from being a senior counsel, he is also a senator. He actually sat in the Senate. So if this was what was on their mind, then it clearly fell afoul of the standard set by the Court of Appeal. This decision is important for a second reason, which is that you've been told a lot about Wambora and others, you've been told about Mate and others, my good teacher as well, I also had a teacher now that is sitting about teachers. Professor Gido referred to a case from the US called Nixon versus the United States. When you look at page 9, all those decisions are cited. And so this is what you might call a wrapping up decision of all those decisions. All the principles that everybody has been cited here are part of this decision. My Lord Justice Mrima asked a question about I think he was asking Mr. Kamogo, at page 12, what is the significance of removal impeached? You will find that at paragraph 16 at page 12. Now, at page 13, paragraph 18, you find the following sentence. It is only in the face of credible evidence of extraordinary wrongdoing, that the conduct of a state officer will be investigated, and even then, only upon sufficient proof of the allegations that an impeachment, removal, or recall will be warranted. 3 tests there. The first one, credible evidence of extraordinary wrongdoing. Secondly, that the conduct must be investigated. My learned friend and Mr. Dudley has told you the need for this committee. It must be investigated. And 3, there must be sufficient proof, not rumors, not innuendo like my good friend Dr. Thakin Kolu attempted to do this morning.
What paragraph? What paragraph is that?
That, your leadership, is paragraph 18. You will find it at page 13. Now, the court then deals with a question the Fiancolo team has raised here, and I'll be getting to that because there's a lot of factual misrepresentations. Yes, Dixon is dealt with at paragraph 113. I won't read all of this because of time, but I'll read paragraph 114. Paragraph 114 is at page 31. To question whether the due process was followed in the removal of the appellant, the Audi Alteram Patem rule requires that those who are likely to be directly affected by the outcome of a decision should be given prior notification of the action proposed to be taken, of the time and place of any hearing that is to be conducted, and of the charge or case they will be called upon to meet. They must be given an opportunity to be heard, to call witnesses, to be represented by counsel, to be availed adequate time and facilities to prepare, and if the accusations are proved, to be given reasons for the decision. You do not have reasons for this decision. My good friends told you they had a thing called tyranny of numbers. I participated in a case called Raila 2017. The most memorable line from the court on that occasion was that numbers are not everything. The process must pass the constitutional test. Numbers are not everything. They then continue, and then they say they are also entitled to challenge the decision, if against them, before a higher tribunal or court. And so there again is emphatic authorization from the Supreme Court for your jurisdiction. I will not read paragraph 116, but only to make a point here. An unfair removal is, in fact, no, let me read all of it. In the process of removal, the right to fair administrative action under Article 47 and the right to fair hearing under Article 50 of the Constitution all accrue to the governor, in this case the deputy president, before a decision to remove him or her from office is reached. An unfair removal is one which, 1, goes against the principles of natural justice, 2, implies that no adequate notice was given, 3, that there was bias, and I'll be returning to bias on the part of the particularly Speaker of the National Assembly, and where the hearing was not fair. Those are all terms extracted from Section 11 of the Fair Administrative Action Act. But they then make a very interesting point. Though a political process, impeachment is sanctioned by the Constitution and the law, and is not a platform to settle political scores. If there were any evidence required or any authority that this is not merely about politics, there you have it. This is not just about settling political scores. They then deal with the question of standing. Now, yes, this is my good friend Professor Agenda told you about, I think this was paragraph 135 and 136, about this question of timelines. And while here, let me just deal with that question. Number one, paragraphs 135 and 136 of the Sonko decision are not dealing with that kind of timeline. It's a timeline of a party who has gotten a stay order in the High Court, filed an appeal, and is now sitting on the stay order and frustrating the hearing of the appeal. That's what this is about. This is not about the constitutional timelines at all. But, and my good friend Mr. Dudley here has adverted to that partially. And let me make it clear what our point is. Under Article 1, if we were to take the argument for argument's sake, you have the committee route. The Constitution makes it clear the committee has 10 days. It's very clear. To use the words of Professor Rigathi Gachagua, read the text. 10 days committee. After committee, the report of the committee can go two routes. If it does not find the charges to have been substantiated, the matter ends there. If it finds some or all of the charges have been substantiated, it then goes to plenary. Those are the two routes available. There is absolutely no time, and I have been listening very carefully. My learned friends for the respondents have avoided studiously, carefully, painfully even, to tell you where this timeline they're telling you is in Article 145 for plenary. There is no timeline given for plenary. Again, to make it clear, we are not saying it is to be open-ended forever. We are saying it must be time that affords you a fair hearing under Articles 47 and Article 50. They refused to do that. I then take you now to the question of public participation and how, but before I go, let me deal with public participation a bit later. Article 140, no, paragraph 148 of this decision, they deal with the question of standard. I will not go into that. They just say the same things I've told you, that natural rules, rules of natural justice must be followed. But at Article 140, at paragraph 149, pardon me, the second half of paragraph 149, which you will find at page 40, this is what they say. The Court of Appeal, in the above case, they are now referring to Ambora, one of the Amboras, also affirmed the elements identified by the High Court as constituting proof of the charges, and they say, they cite them there. One, they must be serious, substantial, and weighty, not silly, as Professor Agenda submitted. There must be a nexus between the governor and those gross violations, and the charges framed must disclose a gross violation of the Constitution or any other written law, and the charges as framed must state with degree which articles or sections of the law have been violated. It's an important thing because my friends for the respondents have blown hot and cold. On the one hand, they dip into the substance and tell you, you know, look at this horrible man, he did this, he did this. But don't look at that, don't look at that. Yeah, he was a very, very bad man. He did this to his family, he did it, but don't look at that. You don't, I'm just telling you he's a bad person, but don't look at that, you know. This is what they've been doing, blowing hot and cold. But this is authority for you to descend to the substance. And I'll be showing you where there's even more explicit authority for you to do so. They then, I think, deal with the question of public participation again, sovereign power at paragraph 156, and they begin answering the question my Lord Judge Ogola has been asking today about what case by case means, and I'll be taking you through that shortly. You'll read that for yourselves, paragraphs 156, 157, and 158. Now, to deal with a question that was raised about public participation here, before now I get into the substance of it. One of the distinguishing factors of the Sonko case as regards public participation was that public participation was being carried out under COVID rules. And the court therefore says, under those circumstances, it was impossible to do, the sort of wide public participation one might require for the removal of a governor. I'll get that particular paragraph for you. And perhaps that's one of the tests for case by case. In 2024, when the petitioner before you is impeached, we do not have any COVID. We have a lot of time, as I've established, but we have an ungodly hurry and are predetermined. Yes, here we are. Paragraph 146, this is what the court said. Paragraph 146, the very last line. The courts also observed that on account of the restrictions placed on physical and personal public interactions due to the COVID-19 pandemic, all the foregoing avenues satisfied. And those are the ones that were being read out for you here. Email, social media, things other than physical. That was the reason. We were under COVID. And they explain it there. That's one of the things they explain there. But let me get into this question of public participation. The first thing I think to underscore is that the respondents, and I think I'm referring now to the submissions of my good friend, is not here. I like honoring all protocols observed, Mr. Gumbo. He's what I think Mr. Mokele calls the Jakwath of their team. At paragraph 294 of their submissions, make the bold and equivocal statement: Senate did not require to conduct public participation. That's why you'll find that submission. They didn't just say it orally. It is in writing in their submissions. Now, we have been referred to here to the BAT case. And I think it's important to identify what it said, because it created a criteria at paragraph 96 of that decision. And it gave what the components of meaningful public participation include. It said, number one, clarity of the subject matter for the public to understand. How were the public to understand what they were being asked to approve or not approve? Number one, when the evidence was not attached, because what was attached were just the grounds. That's number one. Number two, they had not heard from the deputy president to understand what is this issue, what is his response to all these things. As it turns out, some of them in fact all of them, which was spurious, but even 6 that you keep being told here, were actually dismissed. B, the structures and processes, the medium of engagement of participation must be clear and simple. It took an order by Justice Mwongo to direct that where a deputy president elected by the entire nation is concerned, this ought to be done at the constituency level. Because these are the people who elected these people. It must go to the constituencies. Under the Constitution of Kenya, the presidential election is not conducted at the national level. The Constitution makes it clear it is conducted at the constituency level. And what happened? Justice Mwongo's order is issued, I believe, on the 4th. On the 5th, which is a Saturday morning, a notice appears in the newspaper. People are attending to the Sabbath. People are going to weddings. People are nursing hangovers for Friday. Who saw these things on a Saturday morning? You have been told, come today. Secondly, you have been told, come to the CDF office where you normally collect your checks. Your MP has already signed the motion in support. You must ask yourself as a Kenyan, will I ever get another check for my school fees? So even the forum where this was held was biased. You can't have an MP who signed a motion being the one conducting the public participation.
Just to get some clarification, are we responding to legal issues or are we extending this to factual issues? It is important that we get that clarification.
It's legal issues.
Sorry?
Legal issues.
Yes, because my concern is that we're now going to the facts with regard to public participation, as perhaps opposed to just the principles that govern public participation.
I think you should address that.
All right, we'll move on.
Mr. Macharia, your 10 minutes.
10 minutes.
Shy of the 1 hour.
I will be quick with this. But you'll read them for yourselves. They are at paragraph 9. There needs to be an opportunity for balanced influence from the public in general, a commitment to the process, and inclusive. There's a whole list of them you'll see, and they failed all of them. As I said, 0%. Now, you are addressed on some issues here, particularly regarding a case called Njiru and 11 others versus Kenya Kwanza Coalition. My good friend Mr. Milimu said that this was orbit. It was not. The paragraph, which is, and you'll read this at paragraph 489, is a finding. They say, we hold and find, and then they say that the dual role of the speaker is unlawful and unconstitutional. You cannot declare a role unconstitutional in orbiter. That is a finding. Now, my good friend Mr. Tiankolu and his colleagues have made heavy weather of the medical question, and I thought to begin by clarifying a few things. And the things I want to clarify are the following. One, because there was misrepresentation, factual misrepresentation. You are told that the deputy president actually presented his case, and it is only cross-examination that was left. That is not true. The English call it false. It is false. When you look at the Hansard at page 117 of Mr. Mukele's replying affidavit, this is where the Hansard for the Senate is. Page 1117, 1117. This is what the Speaker says. I will ask the National Assembly to officially rest their matter to allow you to usher in your witness. This is talking to senior counsel meeting. Once your witness takes the stand, you will have 2 hours to present your case. That's the first thing. 2 hours to present your case. 2, the National Assembly will have 1.5 hours for purposes of cross-examination. So between our case and their cross-examination, we are given 3.5 hours. We 2 hours, they 1.5 hours. So this attempt to convert themselves into the victims here, that they were denied, there was nothing to cross-examine because nothing was presented. When you read the full proceedings for 17th of October, which ran from page 1116 to 1135, there is no presentation by the deputy president. He is in hospital. That's number 1. Number 2, you are told, and learned counsel Faith Waigo here told you that when you kindly granted leave for Dr. Kone Tukari, that the evidence in that report is collaborative. Why? My good friend Mr. Gumbo, in the Senate, again you will find, tells the Speaker that he's very sympathetic with the Deputy President's health problem. And he says it is no human can deal with it. The Speaker himself quotes Mr. Gumbo and says, when he's giving his ruling, yes, he's giving his ruling. You will find this at pages 1131. In response, Counsel for the National Assembly, Mr. Gumbo, registered his sympathies to the Deputy President. On the one hand, he noted that health matters are matters that are beyond human control. This, no one asked for a report because it was accepted that the Deputy President was in hospital. That was accepted by everybody. Now, at the very end, the Speaker himself ends that session by saying, Honorable Senators, ladies and gentlemen, in conclusion, let me take this opportunity on my own behalf and on behalf of the Senate to convey our sincere sympathies and best wishes for quick recovery to His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya. They then take a vote to proceed to impeach. So the question of a medical report on that day didn't arise. He's receiving treatment. The Speaker has told us, please go and wish him well. Go and tell him Paul Sana, which we did. Another 6 senators you will find from your own from the proceedings when you read also wished him quick recovery. So there was no doubt that he was unwell, and they are all wishing him quick recovery. But then they are laboring under a self-imposed deadline of 10 days. But even on that self-imposed deadline, they have 2 days left. And so senior counsel tells them, give us a day or 2. We think we can get him back when he's recovered. And the medical report, the discharge summary we received yesterday, shows he recovered. So that's what it says. And where is the time to start bringing reports on that particular day? But then he says, give us a day or two, we'll bring that, whatever it is required of us. So that's what happened on that day. So I think it's misrepresentation to suggest that there was no evidence, that this question of health did not arise at all. And so the decision to proceed without hearing the Deputy President was a deliberate violation of his Article 50, Article 47 rights. My good friend Professor Agenda asked what else was he going to come and say that was not.
It's a Friday. Yes, and I'm coming back on
2030 is Saturday.
Yes, that's Friday. Today's Thursday. Yes, isn't it?
22nd is Friday.
14. 21st is next Thursday.
Yes, so
Wednesday is 20. Is next Wednesday. No, I'm away. Oh, next Wednesday. Yes, I'm coming back on 22nd.
Which is what I'm saying is a Friday.
Yes.
So it's a Friday.
It's a Friday. Yes. Yes. Will you be in the office on Friday? Yes. 22nd. Yes. You will. Yes. I'm coming on 21st. Then we can move to 22nd. Yes. Yes. 22nd. Proceed.
Thank you very much, my Lord. I think I want to wrap up now so that I can give some of my colleagues time to come and say a few other things. But allow me to also deal with this summary question. Our full cast of horrors has been raised before you. There will be a constitutional crisis. The country will collapse. Everything will come to an end if you do your job. I'm encouraged to do. Please do your job, because in the same ruling that you delivered in October 2024, at paragraph 158, we have the following undertaking. This court takes the view that it cannot operate under the assumption that its orders will be disregarded. This country has legal mechanisms to address any acts of disobedience. Moreover, the Attorney General, the head of the bar, through Senior Counsel Professor Rigathi Gachagua, has given an undertaking to comply fully with any orders issued by this court in this matter. If you must award us...
My Lord, there was no suggestion in our case that you make orders that are either ineffective or cannot be complied with. The reply cannot be the opportunity to rehash the case. It's not another bite at the cherry. And my colleague, because he's a very seasoned advocate, he knows he's pushing the boundaries, but he's also pushing them beyond the elastic limit.
The boundaries are not even in view. I'm actually responding to his issue. He told you he has a candidate who will lose because our client will go back to the office. I need to make it very clear. Our client has no interest in their client's office, so maybe they can calm down. But the question that had arisen was, there were questions that there is a long history of disobeying court orders, and that once the office of Deputy President is filled, this paragraph 157, it would be impossible to remove the appointee even if the petitioner was successful. We are not asking to be returned. If not, I think I need to make that very clear. So I was just making the point. Don't be threatened. Don't be harangued by people with all manner of horrors. Yes.
Why do you want to limit our orders?
I'm not limiting orders.
But we can return.
Well, my Lord, that would be a most happy surprise. We will receive all gifts. We will receive all gifts, my Lord. Yes, we will receive all gifts. My Lord, the people of Kenya elected a deputy president in August 2026 by a margin of slightly over 7 million. He must be removed, or he can only be removed in a manner consistent with the Constitution. Any impeachment proceedings, such as this one, in violation of 1, the constitutional process, 2, his constitutional rights, is a nullity, and we ask you to so find. Unless my lords and the leadership has any question for me, we will rest our submissions at that point for the first petitioner. We are most grateful to you for the privilege of your time and for the privilege of your attention. Thank you very much.
Thank you. Just sit down, please. Mr. Edith will take it. Mr. Edith will take it.
Just a second.
We are not able to proceed beyond now, so we will adjourn the matter to May 22nd.
Sikia, ni juicy. Flavor zote tamu tena fruity. Yummy na flow kama maji, juu ni tamu kama sali. Ni juicy. Are you bored? Kuna vitu zinakuudhi, usijali my bro, hebu kama taka juicy juni.
Kama invite yangu haikufika on time, but I'm glad to be here anyway.
She was my rival, my competitor. We need to shut this business down.
Hii biashara ndo kila kitu kwenye hii familia, nikufe ama nisikufe.
Kama mbaya. We ni mnoma sana.
One truth can break everything.
Sit tight.
Ready to showcase your football talent? The wait is over. Safaricom Chapa Dimba is back. Bigger, bolder, and better. Safaricom is on the hunt for the next big footballing sensation. Register your team. Visit chapadimba.safaricom.co.ke.